Good evening, folks. This is Omar Serrato with the Tilted Lawyer Podcast. I am joined by the ineffable Lauren Neideigh, who's
That's
dressed for the
me.
occasion.
I'm ineffable.
Oh my God. What was up with your
I
mic?
was trying to do my best you impression. Sorry.
Do I sound like that? I hope not. Jesus
No,
Christ.
you sound way worse than that. I did it too sexy. My bad.
Oh, you sounded, well.
Don't finish that thought.
All right. So I don't know if you caught it, but
Whoops, my bad.
last Saturday night, so I was in the middle of date night, no less, and I had an epiphany while watching. What were we watching, man? We were watching a movie.
I assume you were watching Snow White again.
No, it was the biopic about Bob Dylan with the new Willy Wonka. Had the new Willy Wonka, and he's playing Bob Dylan.
I like that guy.
Yeah, he's really good in that movie, by the way. Oh,
I haven't seen the Bob Dylan one yet.
If you're into music biopics, highly recommend. Highly recommend.
Yeah, I think I saw it. Was it on? It's on Hulu or is it on Paramount Plus or something? I'm gonna watch it.
I think I bought it on Amazon.
Oh, did you? I saw it somewhere. It might be for purchase. I can't remember though.
I'm pretty sure it was like $30, and then they dropped it to $10. It's like, oh, well, I'll definitely pay $10 for it, but $30, get out of here.
Damn.
Those are theater prices.
Right.
No, so I had this epiphany while I was watching that movie. There was a lot of discussion, and a lot of attorneys were going on about how 47.1 is so unfair. And Justin Baldoni can't possibly proceed. The risks are too grave. The fee shifting and the treble damages and the punitive damages. And then I'm like, I mean, my rant, it was like 3 minutes long. In the middle of a date night, no less, one of the live comments was, wait a minute, so does Omar just break out in like legal arguments in the middle of dates? No, I don't. But I was home and I was feeling kind of soft because, I was a little bit lubricated. And my thoughts were, look, if Justin Baldoni believes in his case, he should just fucking go for it. Mm. And if he should happen to lose this case, everything I've heard about Justin is he doesn't care about, going after one person, or he just wants to do the right thing. He wants the right thing to fall into place. That's what he wants. And so many have spoken out against 47.1 about how it is a little bit too overbroad in terms of people that are legitimately defamed. You have to prove maliciousness. Otherwise, you get in all of this fee shifting stuff and, all of this added anxiety into what's already a very anxious lawsuits. It seems a little unfair. So my epiphany, it's not even really an epiphany. It was just like, look, if you believe in your case, then fuck all of that. Go forward and conquer. What's the worst going to happen? You're going to lose. You got Steve Sarowitz that said he's prepared to spend $100 million on this case. I'm not saying he's going to fund like a judgment like that, but if you got people in your corner, and if you have a movement that is trying to push back against false allegations, and it seems like we spent half of 2024 and really the beginning of 2025 pushing back against false allegations against men. You were at the forefront of covering this Laura Owens case, who unceremoniously was victimizing all of these men through false allegations of SH and all kinds of terrible things, fake pregnancies, whatnot. Blake Lively comes along, and it appears under the most unlikely of perpetrators, Justin Baldoni. The more that we learn about the guy, the more he just looks awesome. And the way that they literally attacked him in their pleadings was, oh, he's such a great guy. He's been a great guy for 20 years. So why doesn't he believe? He wants you to believe women. So why not believe Blake Lively then? It's essentially what they seem to be arguing, which is just this bizarre argument. What's up, everybody in the chat? I'm going to try to keep a better eye on the chat tonight. It's really difficult when I go on my rants. I don't know if you caught my live last 2 nights ago when I had Brad on.
What was I doing that night? I can't remember.
You were streaming. I was trying to get your attention.
Were you?
Yeah.
I'm sorry, I didn't even notice. I'm sorry.
I got managed like, how dare you not acknowledge me? And then I left to do my own stream. And then Brad came on.
I didn't know you were there. I have no idea.
Oh, you seem preoccupied. But no, I had Brad on, and I was we were talking about political stuff, and he got beat up a little bit. I felt really bad. But in the chat, the people were saying stuff, and I felt bad that I wasn't paying more attention because things were happening. But it was a very powerful discussion the other night. I'm not going to get into that. I know you're not a political person.
I mean, I listen to people. I follow people who are very conservative. I follow people who are very liberal. I just don't want to live in an echo chamber is my thing. And I also I don't talk about it on my YouTube channel because like there's so many places to talk about that, and I feel like there's so much hate flung at people over political discussions, and I'm like, I want this to be a break from that. But like, this is your channel, man. If you want to talk about something, I may or may not agree, but I'll listen to it. It's fine.
Yeah, Bruce was there. He said I was on edge moderating that stream. I've just decided I'm not going to be afraid of talking about politics. What's going on is way too important. If people disagree, they want to unsubscribe from my channel, then go for it, because I got views that you disagree with. If that's the basis, I could only talk to things that you believe in. Otherwise, you're going to unfollow. Then just unfollow, because we're going to disagree on a lot of things. And luckily, I was really encouraged. There's only like 2 people that did that, and even one of the 2 was like starting to warm up in the comments, like having these really important discussions that weren't normally had. So I've decided, where I was not really afraid, just reticent to talk about it before, I'm not afraid anymore. I'm going to say what needs to be said. I'm going to speak my mind, and we could either have intelligent comments about it or not. And those that don't wish to do that will, I guess, retreat to their echo chambers. Those that wish to have intelligent conversations are welcome.
Oh, Cassidy's here. Hi, Cassidy. You know who Cassidy is, right?
Is she the one that you went on with Podcorn with?
No. That was so. Leanne's also in the chat, but Cassidy has a channel and she covers the legal stuff, and she's pretty great. She doesn't. I don't think she does lives. I think she does mostly pre-recorded videos. But she has like a way about her where she's just like, it's like she's so politely says things that are also very like blunt and kind of critical. It's. I can't even put it into words, but
I can appreciate the bluntness. I'm all for that.
She's great. Yeah. No, I'll just listen, and like sometimes it's not that she's not interesting, but sometimes she's also just very calming, and so it's kind of like when I listen to you, I'll just kind of like it's like relaxing to the point that I almost fall asleep a little bit.
You understand too. I mean, I'm a lawyer channel, but I'm not the conventional type of lawyer channel that's all like completely button up like me. We have fun on this channel. What can I say, man? There's a lot of different topics. There's lots of derailment. There's a lot of poor choice of language.
Yeah.
Interesting wardrobe decisions by yours truly. Yeah. I'm totally not talking shit about your shirt. By the way, I'm so effed when we race. When you come down here, I'm so not looking forward to it.
You have over a month to prepare. I expect you to be like Michael Phelps by then. I
mean, I'll be faster than I am now. I just, it's just not my game, man. We'll see. I'm going to try my best. Anyway, we were on about something, this 47-1. Before we get into 47-1, I will address that because I have things that I want to talk about. That Justin Ricardo says, Omar thinks people deserve respect. F that guy. Yep, exactly.
Disgusting.
Oh, all right. Let's, you had a lawsuit that you found. Well, actually, without a crystal ball, it had hit me up. Said, hey, I just found a lawsuit out of New York. And then the question was, is that what the subpoena where they coerced Jen Abel into handing over her phone was born? Because I know you haven't seen the subpoena. I was in your chat earlier and I asked that question.
Dude, I was muted. Sorry, I was muted. My bad. I was trying to tell you, Katie posted that. So I saw Katie's Instagram post, but I wasn't sure what lawsuit she was referring to. And then somebody tagged me in a tweet. And so I went on with Leanne to talk about it. And I haven't gotten a chance to finish Katie's video yet because I didn't realize it was up before we started our stream. So she's got some stuff in there regarding the company. I don't know if I'm saying it right, Van Zan that's involved there. So you should definitely watch that. But so did you read the thing yet, or
No, what we're talking about? I got it from you like 5 minutes ago. I'm not actually interested in the contents of this lawsuit because it's been discontinued or is no longer active. Is that what's going on?
So the thought is that this was the lawsuit that they had filed in order to get the subpoena to get the information, like the text messages and all that. So the company, which is Blake and Ryan's company, And then it's sketchy. So they're suing John Doe's 1 to 10. And it's like that if you look at the contents of this though, it's very specifically like it's talking about the same things as the actual lawsuit in a lot of parts there.
Yeah.
The reason I don't so my personal opinion is just that I don't I don't necessarily think that this is the case. I'm not saying it's not. Obviously, I couldn't possibly know that, and I'm not a lawyer. My mind is just thinking like I'm looking at this, and I'm looking at this esteemed law firm that has signed off on this, and I'm thinking, would they really put themselves at this kind of risk over something that is obviously improper? Like, I just don't believe that they're that.
Well, this is the
stupid.
summons. This is the complaint, nature of the action.
Yeah.
They're talking about stuff. What's their causes of action? They list the parties, principal place of business, Doe's 1 through 10. Is there a listed defendant here? No, there's not a listed defendant. There's literally Doe's 1 through 10.
Right.
Interesting.
So they're saying like this would have been like kind of the sham lawsuit that they filed to get the subpoena, but then I'm also thinking like they did in fact know who they were suing. So then why would they file a complaint against John Doe knowing that people are going to dig this up later and find out that they did this? And I'm like, are you really that dumb? Are you really
well, they are that dumb. It's not that they're dumb, they're just brazen. And there's a difference. They're brazen enough to think that nobody's gonna. And look, I think that the Occam's razor should apply. I think if there was an issue with a subpoena, I think we would have known about it by now.
Yeah.
I think there would have already been a motion to quash that subpoena and any evidence that was obtained therefrom, either from it being an improper subpoena or it not meeting the notice requirements in California. Because my understanding was there was a subpoena issued, they reference it, and that coerces, I say coerce, if it was an invalid or illegal subpoena, it was coercion. Or she was either coerced or she complies with a valid subpoena. And she hands over her cell phone, and that forms the basis, the foundation for the beginning of the formation of their smear campaign lawsuit that they filed later in December. So this is filed when? In September.
Yeah.
And I'm just looking at the factual background.
So it's in New York State. Oh, somebody's at my door. Give me 1 second. I'll be right.
Oh, dude, I'm just going to read this factual. Yeah, they filed this in New York State court. And by the way, you can serve a subpoena in California for a New York lawsuit. Somebody asked me that. That's not an issue at all. Of course you can do that. But the factual background is as follows. Upon information and belief, the Doe defendants have certain confidentiality obligations to plaintiff regarding plaintiff's business and reputation arising from, among other things, oral or written agreements and or duties of good faith and loyalty. Specifically, plaintiff provided consideration to the DOE defendants in exchange for the DOE defendants' agreement to act in plaintiff's best interest, not to take actions to their personal benefit at plaintiff's expense, freely communicate with plaintiff regarding matters that impacted business and reputation, keep strictly confidential and not disclose to third parties plaintiff's confidential and or private information. Upon information and belief in or around August 2024, the DOE defendants breached the Doe duties by acting in a manner that was inconsistent with and damaging to plaintiff's business interests and reputation. Upon information and belief, the Doe defendants conduct included but was not limited to failing to act in plaintiff's best interest, taking actions to their personal benefit at plaintiff's expense, failing to freely communicate with plaintiff regarding matters that impacted plaintiff's business and reputation, and disclosing to third parties, and failing to keep strictly confidential plaintiff's confidential and or private information. And there's more information and belief. This is a breach of contract claim. What are we breaching here?
I am here. I'm just eating, so I'm not turning the camera back on until I'm done. So just so you know.
Off the top of your head, when was this Abel's phone turned over?
Fuck, man. I'm sure someone in the chat can tell us. I can't remember right now.
Could somebody confirm the date of the cell phone being turned over? Does somebody in the chat know?
Cassidy, help us.
Leisha Chobe says 21st of August.
Oh, there we go.
Or Leanne Newton says that. Amy Les with 5 says, if this is the lawsuit, how can BL's lawsuit use the subpoena from another lawsuit? This can't possibly be the lawsuit if it wasn't born until when? What's the filing date on this?
September 27th.
They received this September 27th.
Yeah.
The date that they signed was September 27th, filed in New York County Clerk September 27th. If it was August, this cannot be the subpoena. It can't be based off of this lawsuit. So I guess that kind of answers that question then, does it? Then it just begs the question.
It's confusing. I don't know, because so it was opened in September, closed either the day before or like a couple days before the CRD was filed or in the New York Times article came out and all that shit.
Yeah.
But and then somebody says, but the conspiracy began long before. Well, that's what I'm saying. Like, so when we were talking on my stream with Leanne, if you use Celbrite to get, stuff off a company device, so like say the day Abel was fired, you're getting the stuff off her device. You don't need a subpoena for Celbrite to get that information. So to me, it seems like they, used Celbrite, got everything off the phone and the laptop or whatever, even the deleted messages, because that's what Celbrite can do. And then sent it over to Leslie Sloan and them, and was just like, hey, look at this. We can fuck them over. And then at some point after the fact, they're like, we need to get a subpoena so we can cover our ass and say this is how the messages were obtained. And then like people are thinking that this lawsuit could have been the basis for that subpoena, maybe. I think is that what I'm gathering. But my opinion is like, this just seems so like, how stupid would you be as an attorney to like sign off on this? Like, I don't know if I buy it.
California doesn't allow pre-litigation discovery.
This is
a New York lawsuit.
Yeah, this is a New York lawsuit. Yeah.
Yeah. I don't know if there's an exception for that rule if it's out of state, honestly. But if you're trying to conduct discovery in California for California lawsuits, you cannot conduct or issue a subpoena without having a lawsuit to attach it to or a case number to attach it to. So if this lawsuit, you know what, I'm just going to research it in New York. In New York, what is the rule with that?
So there's like certain situations you can ask for pre-litigation stuff like that. And one of them is if you're trying to figure out who the other parties are, which is why I thought it was interesting that they were suing as these people are John Doe.
But there's a provision for that. Like, you sue Does 1 through 10, and then you could do whatever you got to do and amend later. That's what the Does 1 through 10 are for. Yeah, and interesting that they stopped at 10.
It is kind of strange.
Is this? Who is this company?
So that is the company. It was. I don't know the actual word for it. It was like not active for like 10 years or something. And then when they went on that break because of the strikes, the break in filming, then for some reason Blake and Ryan decided to like reactivate this company. And then now all of a sudden it's used in a lawsuit here. So
this is definitely Blake and Ryan's company?
Yes.
Okay, so they're alleging breach of contract. They're alleging a breach of covenant of good faith, faithless servant liability. That's an interesting one.
What does that mean? I don't know what that means.
I've literally never seen this cause of action. Upon information believed, plaintiff and the Doe defendants are parties to oral or written contracts which impose certain confidentiality obligations regarding plaintiff's business and reputation and require the Doe defendants to act in plaintiff's best interest, not take it. So it's like a breach of fiduciary duty. It has to be. That's basically what that means. Notwithstanding these contractual obligations, the Doe defendants engage in misconduct and unfaithfulness by disclosing confidential and private information about plaintiff to third parties and failing to inform plaintiff of information and conduct that had a reasonable likelihood of causing irreparable harm. Substantially violated their contracts of service with plaintiff, and such violations permeated the Doe defendants' service in the most material and substantial part. Further, as plaintiffs, employees, contractors, agents, representatives of the Doe defendants owed plaintiff a duty of loyalty, which required them to exercise the utmost good faith. So it's not exactly a breach of fiduciary duty, but it sure looks like it. Like you have a duty to act in our best interest because you are serving us. You're providing a service for us. Is essentially what that means.
Amy says that you can remove her face from the screen now.
Oh, I'm sorry, Amy. I didn't mean to do that. By the way, Kai with the 279 says, two of my favorite people. You're one of my favorite. You're one of my favorite commenters. I'm not going to leave your face up there either. I got to do better about that. And I'll just put a comment and it'll be up there for hours. All right. I'm just working through this lawsuit. I'm just trying to find. There's a couple of things. Look, there's we've been following this theory that was introduced by Anita the Redditor, where in some she had theorized, because there was this Vanity Fair interview with Blake Lively where she starts saying certain things, that Lively had plans to take over this project from like the outset. They were gathering information and they were planning. They caught wind that Baldoni was going to file a lawsuit against them for their behavior, and they had this in their back pocket. It was like a prophylactic move to include like the sexual harassment claims. But if this, I guess they file this and it's discontinued, because all of these causes of action basically reappear in their first amended and original complaints. Yeah, it is. I mean, it might not really give us any insight into the subpoena, but what it might do is introduce another wrinkle into the threads that lead to conspiracy and malicious defamation. But look, let me see if there is. I'm looking for an answer for my question. If you can conduct in New York, subpoenas are generally tied to active litigations. There's a Rules 2302A. Attorneys of record in a pending case may issue subpoenas without prior court approval, but if no action has been commenced, subpoenas cannot be issued without a court order. So it's like the same. So either they had a court order to conduct pre-lawsuit discovery,
right,
or they had no legal basis to do so, is what that looks like. At least on the strength of this New York lawsuit anyway. So if that,
strange to me.
Yeah, here's how it works. If there was no lawsuit attached to that subpoena and nobody's seen it, then whatever they got out of Jen Abel's phone and whatever evidence that came from Jen Abel's phone, like there's this theory, fruit of the poisonous tree in criminal law. Like if you search a car without a warrant or without, grounds to do so, and you violate somebody's constitutional rights and you illegally search somebody's anything. Let's just say they illegally searched your handbag or they illegally went into your house. And when they went into their house, then they found like a pound of Coke just on the table with like lines drawn up. And in the midst of doing that, they found a cell phone and they took the cell phone and they got all your contacts and they figured out everything you've been saying, all the text messages for orders about narcotics or whatever. They found all kinds of paraphernalia. They found your customer list. They found your buyers. They found every member of your organization. And then they start building a case from you. Somebody files a motion to suppress that evidence based on constitutional violations and said, look, they had no warrants to come in the house. There is no exception that would allow them to enter the house and search the house. Therefore, whatever they recovered by virtue of that house search is fruit of the poisonous tree and therefore not admissible. If they're successful on that motion, then all of that evidence that they found by entering the house is inadmissible. It's like a penalty for violating constitutional rights. And so very similarly, in a civil case, if you somehow illegally get your hands on information, for example, Jen Abel's cell phone. So let's just say that they got the entire contents of her cell phone. And I'm talking about everything, like all of her text messages, all of her pictures, all of her videos, all of her internet history, all of her search history, all of her browser history, everything. They just download like gigabytes worth of work. You could put like a terabyte worth of stuff in phones nowadays. And they got all that information. And then they use that information to go look elsewhere. Like they wouldn't have known about the Jed Wallace thing, but for looking through Abel's phone. If that's deemed inadmissible, then arguably and possibly it might just tank the entire case, like gut it from the inside out. Like they might have no admissible evidence to base any claims on, and it would have the effect of the case being not automatically dismissed. He'd probably be like up for motion for summary judgment, but whatever came from Jen Abel's phone, if it was from an illegal subpoena, then it's no longer admissible. And every reference to it in the pleadings, and any reference to anything that came from Abel's phone, meaning other people's phones, other people's communications, or maybe they knew from Abel's phone that she was communicating with this other person, and they wouldn't have otherwise known that. That information gets, in other words, it's born off of this tree. If it comes from that tree, you chop down the tree, and everything is gone. So it could be a fatal mistake if that's the case. Now, I have to imagine that Friedman already knows the answer to this question. I have to imagine that if this was a thing, he would have already filed the appropriate motions, namely a motion to quash and a motion to strike any evidence that came from that illegal subpoena. It's either illegal or faulty for notice reasons. Like in California, you have to give somebody 20 days notice. I think it's 10 days if you effectuate personal service. If it's through the mail, then you get like 10 extra days. But people have to be notified that this subpoena is there. The way that it played out in the timeline that I remember is they brought her into a building and they said, here's a subpoena, give me your phone, bitch. And she's like, what? And she's probably all nervous. Her hands are shaking. She's sweating and, beside herself in fear. And she's like, here, take it. And he probably like surrounded her with like a dozen lawyers and possibly her colleagues and forced her to give over her phone.
We're talking about Jen or Stephanie?
Jen is the one that gave over her phone, right? Am I getting that wrong?
The one that was, yeah. So she had the company phone, but it was tied to her phone number, and they took the messages off of it.
Yeah. So I'm talking. They said that they had a subpoena for Jen Abel's phone, correct?
So they subpoenaed JonesWorks, and JonesWorks had that information from Jen Abel's phone. Yeah.
Okay. So then, what I was saying then, in my mind, I haven't looked at that in a long time, but I thought that the subpoena was for Jen Abel. If the subpoena was for Stephanie Jones.
Yeah.
And they got her contact through from Jones. They got Abel's contact from Jones. That is arguably fruit of the poisonous tree. That's not really a thing in civil law, but the same principles apply. So when I say that they could potentially gut their entire case, that's exactly what I mean. To the extent that all of the exhibits and all of the pleadings for the smear campaign, the defamation, the breach contract, all these other things, potentially some of the, well, probably not the SH stuff, but it will gut a lot of the more meritorious claims that they had against Baldoni. If that's made a finding, now I don't know that that's what they're going to find. I just can't imagine. I cannot imagine a scenario where Friedman has not explored this like way early on, like back in December. Yeah. I don't know. What do you think about that?
No, I agree. I just don't I don't know the ins and outs of the process, so I wasn't sure like how long would it take for them to produce something like that. They're like, you need to show us the subpoena. Is there any scenario where they would not just immediately present that to him?
To Friedman?
Yeah. So like,
I'd imagine he's asked for it in discovery. He's known about the subpoena since that timeline, at least.
Could they have put it off as to like just not show him by now at this point, or would they have?
They've got to produce it.
Okay, but in what time frame do they have to produce it?
Like forthwith. Matter of fact, it's not even they had to. Stephanie Jones would have a copy of the subpoena. She's probably already turned it over to Friedman.
Gotcha. Okay, and I mean, she definitely turned it over to the fucking Daily Mail. So
yeah, they had to. They would. It's like a warrant. You got a subpoena. You got to give her a copy. And then if it was true, I mean, I don't know the whole way that I don't know.
So I just want to add also to this subpoena that was served on JonesWorks. Am I to believe that Stephanie Jones? Could
you remind me though? But hold on, back up for a minute. How was it alleged that Jones was served the subpoena?
What's that?
How was it alleged that Jones was served with the subpoena?
She's now confirmed it in her filings. She said they were served with a valid subpoena.
Well, then what are we talking about? If they're saying it's a valid subpoena.
The thought here is that it was not, in fact, a valid subpoena, and that I think that's the conspiracy. It's like it wasn't actually a legal subpoena.
I mean, if they admitted it in the pleadings, I can't imagine that they weren't going to make that kind of admission. And
well, that's why I'm saying I don't actually think that this. I'm not convinced that this is actually the case that has anything to do with it. Is because I'm like, well, who would actually be so fucking stupid as to do this, knowing that they're going to get caught?
I agree with you.
That's why I'm skeptical. It has nothing to do with the actual document we're looking at. My skepticism is purely, are you this idiotic that you would actually do this? And also the lawyer who signed off on it, are you that idiotic?
Kai says, and thank you, Kai, again for the 279, says Friedman said he still has not seen the subpoena. So that's problematic.
It's sketchy as fuck. It's so confusing.
Either he doesn't care to see the subpoena because he knows that it's valid, or there's something legitimately wrong and it's missing somehow. I just can't imagine that would be a thing that's going on in this case.
My thing was also like, if it's not a valid subpoena and they brought it to Stephanie Jones, are we to believe that Stephanie Jones, who brought an attorney and security guards and all that to Jennifer Abel's dismissal, that she wouldn't have her attorney give it a once over and say like, hey, no, we're going to fight this before like just giving over that information?
Would she have known to do that when she was cornered the way that she was, like basically like serving a warrant style?
She wasn't cornered, I don't think. I think they just gave her the subpoena. Does she have to like right away produce that information? What if she like, does she?
Jen Abel? The way that I remember it,
Stephanie Jones, the boss.
Oh, so, yeah. I keep on wanting to talk about Jen Abel. And,
no, Jen, like as soon as she departed, she exits this equation. So she has nothing to do with the messages actually getting to anyone else.
Okay. Well, yeah, I would think that Stephanie would have given that to her attorneys and have them given it a once over. I'm just saying there's not a chance that there was anything wrong with that subpoena that some lawyer wouldn't have immediately moved to quash. That's pretty standard.
Yeah, that's my basis for skepticism. It's not so much, like I think people are really digging into these documents and these other cases and stuff like that. But my thought is, I don't know if an attorney from an esteemed law firm would be so stupid as to like sign off on all this stuff and continue pushing the narrative that there was a valid subpoena, actually using the words valid subpoena if there was not a valid subpoena. So like, I don't know. I have a hard time believing that, I guess.
Oh,
but then some stuff still doesn't add up. So it's just like, well, then what the fuck? I'm so confused.
Well, I think that there's something to be said. By the way, Anita's in the chat. She says that she's referring to BL's filing as a proof of her subpoena. That's not.
She's like, how do I scream in the chat? She's trying to get your attention.
Oh, Douglas Leak says subpoena has not been registered. He also said something else. They never thought that they were going to go to trial. And so they were kind of, they, Lively and Co. didn't think they would get this far. And so maybe they're just breaking rules. How do I scream in the chat? Hey, Nitty, you could just come on if you want. You know what? If you want to come on and like chime in, by all means, I'll shoot you over a link. While I do that.
Yeah. Well, like so basically, like they're saying, like this was like this lawsuit was like a sham filed as a basis to get a subpoena. So how likely is that the subpoena came from this lawsuit? I guess is another question that we're trying to answer here.
I think that if the dates were August, this lawsuit was filed in September.
Yeah, September 27th.
Whatever sham lawsuit would have been filed before the subpoena.
Why I would say the subpoena was given on October 1st.
Oh, people in the chat were saying it was August.
So that was when Jen was fired. So that's when they got the information from the phone, which they then...
Okay, so then that changes everything. Then yes.
Right.
If the subpoena was served in October and this lawsuit was filed September 17th, and it's now since been dismissed and they named 0 defendants, then yeah, potentially. And more aptly, I think, for Baldoni's case, when he's facing 47.1, I think it's really suspicious for a jury to consider that there was this mysterious lawsuit filed in New York that contains no defendants, that has boilerplate language, not really referring to anything, and was the subject of a subpoena. Now they're going to have to get a copy of that subpoena. Friedman says he hasn't seen it yet. So maybe it's really a thing. That they just set this whole thing up to get some kind of a bullshit subpoena, to get evidence and prep for a lawsuit that they were going to file in December. And I want Anita to come on because she has been like on this for like a month now.
Yeah.
Let me see. Hey, Anita, it's the same link from last time. The last time you were on my show.
You say that because it's always 50-50 with you. It may or may not be the same link as last time, Anita.
If it's not, no, I'm pretty sure it is, though.
Yeah, that's good there. So it would be good to have her to catch you up because I've been so distracted and I'm also exhausted. I'm eating for the first time and I don't know how long because I could not eat all day. So I'm trying to steer us in the right direction and I'm just like I'm failing apparently per the chat. But
is it because of by the way, Anita sent you that link. Is it because of food exhaustion or whatever? Hunger pains? Where's my violin?
I was too stressed to eat all day and then now I'm just kind of feeling like I'm a little out of it almost because I haven't eaten anything. So yeah, maybe.
Judge Liz said she would toss it under those circumstances. Who is Judge Liz?
She went on Ask Two Lawyers today. I didn't get to watch it, unfortunately.
I didn't catch it. Khaleesi says you're allowed to eat. You will never fail, Lauren, ever, but please eat. Yeah, eat your food. Why would you deprive yourself? I'm just kind of waiting for Anita to chime in. So listen, this kind of just brings me into my next point.
Yeah, dude. Anyway. Somebody said Cassidy needs to get on. I wish Cassidy could come on. I think that she, I don't know if she can or not because I know that she has had some stuff going on.
If you can, send her a link. She's welcome to join. Why not?
Yeah, Cassidy, if you're still here and you want to come on, let us know.
Oh, Liz Scherer, the Parkland shooting judge.
Oh, I haven't gotten to watch.
She talked about this case.
Well, they were asking about it today on their stream. I just didn't get to watch, so I'm not sure all that was said.
Oh. Is she in the chat?
Who?
Somebody said hi, Judge Liz.
No, I don't think so. I don't think so.
You guys trolling me for? No, we're waiting for Anita.
I don't think Judge Liz would appreciate my brand of humor, so she better not be.
No, but when I first started my YouTube channel, she was one of the first cases I covered. Judge Liz from Parkland when she was yelling at attorneys. Oh, yeah, she's really good. Amy Les with a $4.99, thank you so much, says, if this is the lawsuit, how can Blake Lively's lawsuit use the subpoena from another lawsuit? Yeah, they can. That's just basically discovery, and if it leads to other stuff, then you have it in your possession. The reason why you issue subpoenas is to get evidence. Once you have that evidence, you can use it for whatever you want. It's been disclosed. How do you think the Cosby? It's the same reason why, by the way, he's out of jail. That's another show for another day.
Watch that one. Shit.
Yeah, April Love is a new member. Thank you so much for becoming a new member. I think we got to this one. Friedman said he hasn't seen the subpoena. And then Amy Les says, Judge Liz on Ask Two Lawyers said the same thing on illegally obtained info. She'd toss it if it was in her court. Fruit of the poisonous tree gives best tainted info. Yeah, you can't just illegally get stuff. You just can't. It's an incredibly stupid thing to do. Now, was this a sham lawsuit for the purpose of this? I think it's arguably it is. I'm reading the language. Who is the attorney that wrote this? Who's it signed by? Manette, Phelps, and Phillips. Who are they?
They're the lawsuit representing them. One of the lawsuits representing them currently, I think.
Okay.
Yeah.
Anita, how are you? Welcome.
Hey, Anita. What's up?
Well, I think she's muted.
Anita, help! I need to eat my wings.
Oh, it says I can't unmute.
I need you to talk now.
she's muted herself.
Anita, can you mime? Turn the camera on.
Oh, I seriously doubt she's going to be turning the camera on. Well, she's having mic issues.
I was just kidding. Don't worry about the camera.
Yeah. But listen, it ties into, look, this is the case. This is what I was trying to say last Saturday night in my 3-minute rant. If Justin Baldoni believes in his case and he has the receipts and it appears like he's gathering the receipts, I've been stating that I think he's got enough borderline to argue maliciousness based on Ryan Reynolds' conduct. I've been saying that to the extent that she can show, or Friedman can show, that Ryan Reynolds was an agent acting on behalf of Blake Lively. I think that you can prove maliciousness in this case. That really is kind of the only defense to 47-1. If they believe that they have in this case, they really believe this is a smear campaign. And not only do you have all of the stuff that Ryan Reynolds has done that we've talked about, going to insiders, going to future employers, calling him a sexual predator and, doing that whole thing. Aside from them making demands, breaching contracts, breaching agreements, I don't care if they were signed or not. They had understandings about how they're going to make a movie, and they continue to inch by inch push Justin Baldoni out of the movie, steal his PGA credits, not cooperate in editing of the film unless they were allowed to control certain things. And now, if you could add to the equation that this sham lawsuit was filed, it's really interesting that they don't list any defendants. That's kind of key.
Oh, hell yeah. I heard Anita's voice. That means I can eat my wings now.
Oh, shit. Hey, Anita, what's up? How are you?
I'm good. How are you?
I heard that you were trying to get my attention in the chat, so we brought you on.
I was screaming as you guys were talking. I was like, no, that's not how it went. So sorry.
Oh.
I was just very excited.
You have to talk to us in a scream the rest of the time.
Yeah, I was like, okay, I haven't screamed in a chat before.
Yeah. So tell me how it went. What am I missing?
So the timeline was that the apology was demanded from them on the 12th evening. Okay, so you just have to, let's go from there.
Okay.
And it was demanded for them, and they refused. And that's when Abel wrote, he needs to get Friedman. Basically, based on that timeline, Friedman is on the case.
The 12th of what? The 12th of
August. 12th of
August 12th. Okay, yeah. He needs to get Friedman. I remember that.
Yeah, Friedman joins the case then. And then just let's pause there. And also in previous messages, we have proof that they had been documenting as early as May 17th, everything that had been happening. Just keep that in mind.
Let's 24.
May 20. Of 2024. Okay. But Friedman joins in August 13th. And then that is when they had like all the negative stories, and they refused to get to say sorry, to apologize. And after that, there are text messages that are attached in the New York lawsuit that are filed by Baldoni Friedman that shows that Leslie is basically, a journalist is saying that Leslie is calling and asking people to say that, oh, can you please say Melissa planted stories? That's what was happening in behind the scenes. And in one of them, journalist tells that to Leslie Jones, oh, Jennifer Abel is a PR for Baldoni, but she's leaving Stephanie Jones' company in 2 weeks. This is like straight out written there. And this is where the conspiracy starts. They reach out to Stephanie Jones or something, this is speculative, but this is the thing that makes sense, I think. And because Jennifer Abel was going to leave on the 23rd, there was nothing, they had like disagreements, etc., but there was nothing. And on the 21st, she gets ambushed and she gets a Celbrite, I don't know how you say it, she gets her data extracted. That same day, Leslie calls Melissa Nathan that they will be sued. And then the funny thing, I don't know, it is like all the negative stories about Baldoni are quiet. And this is the theory, is that there was no smear campaign, and they saw it in their text messages, how Baldoni was actually quashing all the negative stories about Blake Lively. And this is
Right.
where it is. And that is when Leslie also is contacting, trying to get any kind of news source, try to find like a way to say that, oh, they've been smearing, because there was no retaliation. Their whole thing has been, their extortion has always been that they're gonna use the 17 demand list and then, you know, bully him further. But they saw that they have Brian Friedman, and they have been documenting, because it's in the messages, because actually Jennifer Abel had way more messages she put than Baldoni saw, because in her phone Jed Wallace was also there anyway. And that's when actually all of a sudden, I think September 10th to end of September-ish, all the articles are talking. I was like, oh, Justin Baldoni, the director and the co-star of Blake Lively, and Ryan Reynolds wants to, you know, is ready to offer millions to buy the movie. All of a sudden, he's not a predator, you know?
Yeah.
So literally, like, after they get the phone, there's not this thing. By the way, I've gone a bit psycho, and I've done more research about this. I have like articles.
You're not psycho.
I was like, I need to be in this, like, you know, like, I'm so obsessed. I was like, why are people not seeing it? Because every time something comes out, it proves it. The whole talks shift, you know, and ironically, there's no more article about him buying the movie. I think September 20 something, actually it ends. It just pops up once in one article, October 6, but I think that article just re-quoted another one because it was word by word, just like the other one. Anyway, I think they offered to buy the movie and they said no. And then they saw, you know, I was like, okay, I genuinely don't think Baldoni wanted to file a lawsuit.
When do you think the offer would have been made?
It would be in September.
Okay.
It's in September.
When they filed the lawsuit. Okay, I got you.
Yeah. I mean, no, the one in September, that's when the articles were coming out, right?
That's what I mean, the Sham lawsuit.
Yeah. And everybody is like also saying everybody remembers they tried to buy it. So anyway, my theory is this way. They tried to buy it, but knowing them, like Baldoni probably, this is absolutely speculative, and Baldoni probably said, I'm not going to sue, just, you know, leave me alone, you know. But knowing, or whatever we have seen, I think having so much evidence of extortion in their hand, because they had been documenting, and in the comments it says like, oh, they talked to cast and crew about his behavior and everything. So it's not just like documenting with the messages, but they have a full, I don't know, files, you know, they're confident.
Well,
and
could
then,
I just, I just got to tell you.
Sorry, I'm just so passionate. Yes.
No, you're good. But what I'm understanding, I understand the theory, but if this was indeed a sham lawsuit in California, has anybody else addressed like this sham lawsuit? Was it known before today? I know that I'm late, but is it like this the first day?
So I've seen this before, but I didn't connect the dots.
Okay.
So like I looked into their companies, all their companies, and the ones that they had in the last, I don't know how long. And I found the different lawsuits in New York and in California. So I've seen this before, but I didn't connect the dots. I was like, this looks like something, you know, just stupid. And so I never thought about it again. And then Katie from Without a Crystal Ball brought it up tonight. So this is the first time anyone's really looked at it.
Well, let me just tell you this, that in California, I got to get this out because I'm going to go crazy. Even though I'm just, look, I know that Friedman hasn't seen the subpoena yet. Maybe he's waiting for it in discovery or something. I don't know. But if he finds out that the subpoena was based on this lawsuit, and I got to say, man, I can't remember a time where I've seen a lawsuit without a named defendant. This usually doesn't really happen. You know who the defendants are.
I don't know if this counts, but like
that was for the New York Times. That was for the New York Times litigation to cover. Yeah. They never thought that this was gonna go this far. That's what I've been saying from day one. And actually,
that's what I'm saying. Yeah. So the fact that it's Doe's one and they didn't think it was gonna go this far or whatever, they use it to get a subpoena. If they abuse the discovery process like that, I know in California, you can 100% ask for sanctions. You can ask for attorneys to get kicked off the case. You could ask for monetary sanctions. You can ask to quash the subpoena after the fact and exclude any evidence that was obtained by virtue of the subpoena. And you could probably even ask for an evidentiary hearing to ferret out what specifically was obtained by virtue of the subpoena. Like, where did it lead you to? Because none of that should be inadmissible. Nobody should be allowed to file a lawsuit for the purposes of attaching a subpoena to conduct pre-trial litigation. In other words, they filed a bad faith lawsuit. There's a specific case, O'Grady versus Superior Court, where the courts, it's a 2006 case, the court condemns the use of subpoenas in sham lawsuits. And there's a quote: "The discovery process is intended as a device to facilitate adjudication, not as an end in itself." And the consequences of that, they're not really set in stone, but you can seek sanctions. You can request a protective order of any evidence that's being asked for in the subpoena, but it's already been issued. And so realistically, what you're asking for is to quash the subpoena and to make inadmissible any evidence that was obtained or directed to have been obtained by the sham subpoena, let's call it. I don't know if New York has a similar thing. Just a straight up Google search. There's a motion to quash. It's under CPLR 2304, and that says a motion to quash or fix conditions or modify subpoena must be made promptly in the courts. A subpoena is not returnable. Okay. To successfully quash a subpoena, the moving party bears the initial burden to demonstrate that the information sought is utterly irrelevant or that the process will not lead to legitimate discovery. If this burden is met, it then shifts to the party issuing the subpoena to show that the information sought is material. I know that this is a New York case, but it was served in California, and it's implicating California law, and it's a federal lawsuit at its heart. And so I don't know which rules are going to apply. I'm just looking at the New York rules for fun, really, we should know these. It says that New York allows for pre-action discovery under 3102C, but only by court order and when the petitioner demonstrates a meritorious cause of action and that the information sought is material and necessary to the actionable wrong. While New York recognizes the tort of abuse of process, courts have held that the mere initiation of a lawsuit, even if meritless, is insufficient to establish such a claim. So it's a little bit different in New York. In California, it looks like they would just toss it out. This is going to be another choice of law. Like, which law should we apply? Because it looks like if they apply New York law, they're probably fine. I don't know what the federal rules would say to this. If they apply the California law, then obviously the lively parties are going to be prejudiced because it means that their lawsuit is going to basically get thrown out. Or not thrown out, but subject to summary judgment. So there's a lot to consider. There's a lot of things that can happen. I don't know what all the ramifications are to this. I just know that if this becomes a thing, there is a chance, there's a universe out there where the lively parties' lawsuits are gutted because there's a finding that this was a sham lawsuit for the purposes of effectuating pretrial discovery that wouldn't otherwise be admissible, running a ruse on the court system, filing a meritless lawsuit. It was a sham lawsuit. Therefore, anything obtained under that subpoena from the sham lawsuit should be inadmissible. But then again, it begs the question, if this was even a thing, why wouldn't Friedman have not done this like a while ago?
Because he wanted to clear Baldoni's name first, because if he dismisses it from the get-go, so the point of this whole thing was that from day one, they've been saying they want to clear his name. And this is what they've been trying to do. And he did that. And they would have done it in discovery and dismiss it later. Because if if he dismisses it early on, it doesn't clear his name. The case has been all about clearing everybody's name that they have smeared with this NYT. And this is if you go back and see how on the 20th, when they shared the CRD complaint with Friedman and all the parties, they immediately sent cease and desist. They sent 3 days in a row because Friedman from next day, he went, I'm going to create a website and started, showing that the truth will be revealed. They applied for AEO just to cover so that they could settle behind closed doors and so that they can spin the narrative. But Exhibit A effed their strategy really badly. Yes. And now they're doubling down and they're trying to find a way out. That's what I think, because if you still read about how they're replying to their motion to dismiss, that does not sound like a person who believes in what they have. They're literally just saying like, oh, if I dare Brian Friedman to sign an affidavit, you know what I mean? That's a PR
Yes.
thing. And
Yes.
if you think about, like, let's say a person was SH'd, or, you know.
By the way,
and-
look at how all the people in the comments like love you, man. Like you're like a superstar.
Sorry,
your
I am representing the Reddit that's been screaming for months now, I think. So and everybody, like, it makes no sense, and that's what I said. Like, Blake Lively's motion to dismiss, the fact that she had 3 privileges attached, that's not, that's premeditated. There's no way that's not premeditated.
I want to answer Douglas Leake's question because it's an important one. How does your theory work with Cali Law 47.1? So 47.1, I think that they're going to, for the SH claims, apply California law. With California law, you have to deal with 47.1. And there's been a lot of lawyers going up and down afraid of the fee shifting provisions of 47.1, where if you are unsuccessful in a defamation claim, they treat it as like an anti-SLAPP kind of a lawsuit. Like, oh, I've been accused of SH. I'm just going to sue for defamation. They got sick and tired of that. They said that victims don't deserve to be unceremoniously treated this way. So if you want to bring a defamation suit, fine. Treble damages, punitive damages. And what does that mean? For people with hundreds of millions of dollars in the bank that are already spending millions of dollars on this case, it means that if you lose, even if you win your other causes of action, it may cancel out the debt. It might still subject you to paying Lively millions of dollars because you failed to prevail on the defamation claim because of the anti-SLAPP provisions and all those things.
If they have proofs that they've been documenting how this was malicious.
Yeah.
Well, and also another thing, Brian Friedman has everything that has been happening behind the scenes, right?
He's pretty confident.
Just so much, there's so much more they will discover in communications between the parties that they are not privy to, And
Matalian says that this is kind of my next point. So if we could prove, all right, look, let's just start with the fact that there's a sham lawsuit for conducting illegal pretrial litigation. That's already bad faith activity. It's defined as bad faith. It's defined as litigating in bad faith. If you start with bad faith litigation and then proceed to file a prophylactic SH claim that has absolutely no bite and no merit, that's going to piss off. I think it's going to piss off a jury. I think the reason that Friedman is so confident in this case is that the allegations of SH are so ridiculous. There's not a jury out there that's going to find in her favor. And I think that they are pretty confident in what they have and that they're going to be able to prove malicious defamation. I think that they are resting their laurels on this idea that Ryan Reynolds acted as an agent on Blake Lively, if not by contract, then implicitly because they have shared interest. They're literally married. He had no reason to go defaming Justin Baldoni, but for trying to get Lively the rights to that movie. Therefore, where we can't find contractual agency, maybe we could find implicit agency and get around it that way. That would tie in Ryan Reynolds' actions to a malicious defamation claim. All of the stuff where he's calling him a sexual predator, where he's calling him all of these things to future employers, trying to get him kicked off of the film, trying to get him kicked off of future projects, all of those things. You could tie in all of that stuff. And it's like, well, how do we bring Lively in? Before it was just like literally mostly Reynolds' actions. You could say some of the stuff that she was doing on set and being unreasonable, things like that. But now if you could add on to that we have this whole timeline of her bad behavior and then a sham lawsuit for the purposes of issuing a bad faith subpoena to obtain evidence that is now arguably inadmissible, I think that you got a pretty effing solid case of malicious defamation. That's how it ties into 47.1. And malicious defamation, the ability to prove that is a defense against 47.1. That's how it ties in, to answer that question.
By the way, somebody asked why they sued Sarowitz, and I had already explained in my theory. So in order to spin the narrative preemptively, is that the right word? You know, in order to spin the narrative preemptively against the extortion, you know,
Yeah,
she
that
was
makes
like, oh, they had to show them as powerful people. They are not, you know, compared to Blake.
I mean,
and Sarowitz is the billionaire. And then they showed him as if he was in the birthing or like the intimacy scene. And they said that, no, he wasn't. He just, when they were building the case, literally, if you look at her SH allegations, it looks like she was literally going back in her memory and writing what happened. And because, based on my theory, because she would have already been confronted by the fact that they have extortion case, she didn't have access to the dailies and everything probably at that point, you know?
Yeah.
If you think about that scene, the dancing scene, how, you know, how it was portrayed, they didn't have the way she described, oh, it didn't have a sound, boom, there's a sound, you know? Like, if you go, this is the speculative part, right? So,
well, I think it's like a lot of people
makes
said.
Sense.
It's even like you said, like nobody expected it to go this far. I think that they were banking on a lot of things. I mean, number one is preemptive.
And this whole thing that, oh, he promised that he's promising to see 400 million in quotation marks. Again, they thought they're gonna file the lawsuit and then they're gonna countersue with extortion, AEO settlement. They didn't expect Brian Friedman to go nuclear.
Well, just because they're, you know, Harvard trained lawyers or whatever, doesn't mean that they don't make mistakes. And they've made a lot of mistakes in this case. They have. The inclusion of Jed Wallace, why? The inclusion of Sarowitz is questionable. Maybe it was to spin the net of, you know, the Wayfarer parties are trying to smear Lively's name because of what? Her story makes less sense the more that I dive into it. And the more that starts to come out, it just really feels like they had this plan to take over a movie that didn't work out the way that they hoped. And their last card that they thought wasn't going to blow up the way that it has was, I'll just accuse him of SH. I will be a victim. Me too. He's supposed to be this really good guy. He's going to want to keep this out of the press. He's not going to want this to go public. He's going to settle out of court. He'll go away. We'll just say, look, there's grant us the movie rights, and then we'll drop the lawsuit, and he'll say, okay, and that'll be done. Over and done with. Maybe that's the thought. Samantha Glover says, Omar, I'm just now hopping in and wanted another lawyer's perspective. Recently, Brian Friedman said he has seen the subpoena, but it doesn't have the case number or case name. Well, they better effing tie it to one then, because it's either illegal, it's either an illegal subpoena because it's not tied to a case, a defective subpoena because it's not appropriately filled out and therefore defective on its face, which honestly, I'm not sure if that's the reason that they could do much with, because they've probably waived whatever objections they would have had, whatever damage is done, or it was a subpoena born in bad faith that would have been, if it was attached to anything, would have been attached to a sham lawsuit that would subject the attorneys to punishment, to sanctions, to all kinds of bad things. And it could possibly have the end result of striking whatever evidence was born out of that subpoena. That's the way that I'm thinking right now, the way that I'm connecting the dots from this. This is super freaking suspicious. Who do you even serve?
Sus. This whole thing is sus. This whole case is a sus from day one. So,
yeah, I cannot remember a time where I've ever seen a lawsuit filed without a named defendant. And I sincerely doubt there was ever any court appearances. They probably never went in front of a judge. It probably just got dismissed. I don't know. Perhaps like they could make like a statute of limitations argument. I don't know. It was a company that's been defunct since 2013 is what I heard.
I have a question.
As
I will need your legal perspective. So this is because this lawsuit was discovered, I don't know, 12 hours ago. I don't know. Anyway, I just had an idea because somebody mentioned that Stephanie had also sued in her lawsuit against Wayfair, Abel and stuff, that it was them plus John Doe's 1 to 10. So now I'm just thinking out loud, help me out. So let's say one of their backup things would have been that maybe they concocted it in a way that maybe they hired Stephanie as their, PR or something, and she would go and, try to find a way where her workers leaked information about Blake Lively, and that's why I don't know, like this. Do you know what I'm trying to say, or am I too confusing? I can't express it well.
It's like, what time is it? It's like 10:41. The words are spinning around my head, but I think I kind of get
I'm
the
on
gist.
2 over here. What do you mean 10:41? You're not that old, Omar. Come on, keep up.
I know.
Sure somebody gets me, but maybe they're one of the things, because Stephanie Jones sued them in the same state. I think the state, New York. What is it called? State court. What is it called? On the 24th. So the New York Times came out on the 21st. So that was about CRD complaint, and then Stephanie Jones suing on the 24th. It would be like a double confirmation that the smear happened. And again, they didn't expect Brian Friedman to go on the press and talk about what he has.
Well,
and
that part is clear.
By the way, and another
Continue.
thing is that actually, when I was doing research, so they were given the CRD, Brian Friedman, and TMZ actually published that there was a CRD complaint before New York Times did by 2 hours or so. I think this was the 4D chess that Brian Friedman made them, I have a theory that they even like threatened, we're going to go to New York Times. And then Brian Friedman was like, come at me, he leaks, he forces them to do it. And then, Stephanie Jones files, if you think about how it's one after another. And Brian Friedman's like, we're going to absolutely sue them. And they have to sue on the 31st. That's my theory. What? Sorry. I'm like, I believe
that's a crazy theory. I can't tell you that it's wrong. I would believe it if it was true. It's plausible for sure. It fits. It fits. Samantha Glover says, also, Omar, caught your stream the other day and felt bad. Unfortunately, there are some who can't handle a different opinion. This is why I love your channel. You treat everyone with respect. Yeah, I was actually, Lauren, we're talking about the political thing that we did the other day with stuff. Where I was
you were talking about that in the beginning.
Yeah, I brought on Brad and we were having like a really important discussion. It got heated in parts, but it was never like unfriendly heated. It was just like passionate. And I was encouraged that I might have lost 2 subscribers, and then one of them came back because they felt bad because in the comments, I felt like it was positive. I feel like there's a lot of people. Look, there's nothing wrong with talking about politics. We got to stop being so afraid of sharing our opinions. That's how people become divided. I ain't talking about yours. You don't talk about mine. And then together we will continue to hide in our irrespective caves, and we'll be so far apart, we're not going to recognize each other when time comes. That's kind of what's going on. So I'm never going to shy away from talking about politics. I'm not going to do it today. But thank you so much, Samantha, for being in there and saying that. I was actually really encouraged with how everything turned out, even in the aftermath. It was a good talk, and I'm going to be talking about it again tomorrow because some important stuff happened that I'm going to address before we do FLAD. By the way, Anita, you doing FLAD tomorrow or what?
Sure. It was fun last time. Yeah.
Yes, ma'am.
I enjoyed.
Yes, ma'am.
Hey, I might have to dip because it's like 1:45 and I'm exhausted.
Oh, yeah, do your thing. You're good. Hey, thanks for coming on, though.
Yeah, Anita, it's good to talk to you again.
Oh, thank you.
Yeah, well, go get your beauty rest. Just don't go outside for any reason.
Only if I'm naked, Omar.
All right, stay away from werewolves. What could I say? All right. Kai says, I think Samantha read wrong. The media has seen it and has no case number or specifics, but Friedman hasn't seen it. If it doesn't, well, it wouldn't make sense to me that the media has seen it and Friedman hasn't. I don't know. I guess it doesn't really matter. He's going to see it at some point. But then it just begs the question, like, even if he does see it, is he going to do anything about it? Does he really just want to take this to trial?
I will tell you, and this is another thing. It's not about him knowing. He knows about the subpoena. He's not stupid, right? So I'm sure.
Yeah.
And my other thing is that when he did the answers to the complaint, and he made a statement in the press that is like, we're not going to do motion to dismiss because they're going to be, they're going to be dancing with their words or something along those lines. They're going to basically, he has been making them talk so that they can watch how they're backtracking. And that has been his whole thing. He's like, I'm not filing motion to dismiss.
Not without doing a deposition?
Yeah,
I was going to say, I was wanting to make that point earlier. He hasn't filed a 12B6 against Lively.
No,
he's not trying to get them dismissed.
He has declared war after New York Times, and he's been winning.
I've said it. There's no part of Brian Friedman right now that says to me he wants to settle the case. I would argue it's the other way around. I think Lively wants to settle the case. It seems. That's the reason. I don't know if you caught it, but like they had these discovery battles a couple weeks ago where he was asking for like very reasonable extensions. And then the Lively part is like, no, we're not giving you an extension. You got till the 18th.
They're petty. They're petty because they're losing.
But you know why you do that? You do that because you're trying to pressure the other side into a settlement. You're trying to just stress them out, And
also, like, I don't know about that part. It's like, I guess if you have so much discovery, you're bound to make some mistakes or something. But with the theory that they have so much already, whatever they're going to find in discovery, it's just going to strengthen their case. My other theory is that they'll probably go all the way through discovery, and like based on whatever they will find, Blake Lively is going to try to spin the story again, rewrite, whatever. Or if they cannot do it, they're going to either have to settle, find a way with an apology, or go to trial.
Anita, there's so much to this case. There's so much to this case.
You need to read my PDF,
Do you have an updated one? Another updated one?
Yeah, I think you would block me if you saw my updated PDF, but don't worry.
I would not block you. I just have to try to make sense of it. I'd have to like read it twice, and slowly.
I actually after talking to you and listening to it, I downloaded like an application. I've created like a timeline explaining shorter, but like making good points. I can share that with you.
Yeah.
You can.
Yeah. Well, I'd love to see it. By the way, Akoneta, thank you for the 5. It says, enjoy you always, Omar. And I enjoy you always being here. Especially so late at night. Somebody had asked me if I had heard of the Reality Bites podcast. I have not. Have you heard about that, Anita?
Yes, I have listened.
What is that about?
They basically talk about the industry and the legal background as well, and also about how New York Times is connected to Leslie Jones. And there's another journalist who is friends with Blake Lively, or, something along those lines.
Yeah.
And how basically the theory is that New York Times just accepted the subpoena, the fake subpoena, because Leslie Jones, allegedly, I'm supposed to say that, Leslie Jones was the source for Harvey Weinstein's, like, all the stuff. So with that theory, Meghan, like, kind of owes her, Pulitzer Prize to Leslie, and they were so sure that, Justin Baldoni is gonna fold. Because that's what he had done all this time, right?
Right.
And I think they're all shocked. Good. Anyway,
you got to send me your new PDF.
Yes.
Maybe I'll put it up for. Is it on Reddit as well?
No, not yet.
Okay, you're still working on it.
Yeah, but some people who had watched your stream, they were saying that they want to read the theory.
Oh, I know. I know.
And I had shared, but I think it's still not as good. How it looks in my brain is so much better. I cannot translate it, and I don't. My mouth and brain do not coordinate when I have thoughts like this.
Yeah, no, I got that problem too. It's a lifelong struggle. So
I've been trying to make it in a way that it's not just only the people who are obsessed with the case, but those who don't know the details the way that I do. I don't know if I'm ashamed of it or proud of it at this point, how much
you have like an encyclopedic knowledge of the case. It's fascinating. It's like, gosh, I'm just you have this map in your head about where everything goes. It's quite the thing. Peapod asks, Omar, where did you get that humidifier? It's a oil diffuser. I guess it could be considered a humidifier, but I got them both off Amazon. I should probably put links up to my humidifiers. They smell delightful. I think I have what do I have in there today? Oh, I got some brown sugar with no, just brown sugar then, I guess. The other day I had like hot chocolate with marshmallows. It always smells like dessert in my house. It's just how it is. Redondo Beach says, props to Brad for coming in debating. I respect him for that. Yeah, he came in and he faced a buzzsaw, man. He got a lot of comments against him. He got a lot of negativity, but he came in and he represented his arguments. I didn't ask him to change anything for me. I wasn't trying to convince him of anything. He wasn't trying to convince me. We had a good, intelligent conversation that was healthy, and we're still friends, and he'll be on Flad tomorrow. So Douglas Leak says, or Freeman and co. don't need the extended time, but wanted to make them look bad. That's also a possibility. Look, I always say that discovery really doesn't affect the attorneys much. It's mostly the paralegals that suffer, and they got plenty of them. So I think that they're going to be fine.
I volunteer.
Yeah,
I mean, love to.
They'll comply. They said they'd already complied with. Douglas Leak is a sharp guy, man. I like the way that he thinks. Maybe they just did it to highlight to everybody and to the judge how they're basically operating in bad faith, and this is a thing for them. And so that way, when we make the argument, if they ever make it because of reasons, it's easier for the judge to believe that this was a sham lawsuit for the purpose of conducting illegal pretrial discovery. Maybe that's a sharp point. I like it. The silence, what is this? The silence for real or from the lively camp has been defining. I think it means deafening. Will that continue today? Probably.
She's enjoying her time of the influential person of the year. Yes, she has been influential.
Yeah. I don't know if they're ever going to release the Blake depositions. I wish they would. I hope they do.
Is it true that once no, they might seal those, right? But they
Yeah.
would they give transcripts though?
Not likely. But they may. You never know. I've heard Freeman has only lost one case. Is that true? I'd venture to guess that's probably false.
Actually, he's known for settling, apparently.
Well, most civil cases settle, though. I mean, like, honestly,
yeah.
like in civil litigation, like 95% of cases settle because nobody wants to risk all that money going to trial. Like, the thing is, criminal trials are a thing because people are literally fighting for their freedom. There's no amount of money to save them. They have to, plead guilty to 25 years or, I'm going to jail for 25 years anyway. I might as well go to trial. That's why there's so many criminal trials. And even then, it's extremely low, the percentage of criminal trials that go to trial. Civil cases going to trial is different. The reason why those cases settle is almost always for monetary considerations. Like I tell my clients that, look, you're this far in, they're literally offering you $600,000 right now. Right now. Or we can go to trial and you may get an award of $600,000. You might get an award of $1 million. But the legal cost is going to jump from like $50,000 to maybe $400,000. And do you got that kind of scratch? Because not all cases are born on a contingency. They got to be able to fund the lawsuit. And so the ones that are on a contingency, like the lawyers are usually trying to convince their clients into taking settlements because they just, look, they're going to take their third and bugger off. That's how it's going to go. But when you have clients that have endless amounts of money, then, oh, yeah, we're going to do a trial. Sure. So we'll see. But I don't know. I don't know any attorney that's undefeated in trial. I don't know anybody that's only lost once, except for the fictional Harvey Specter. If that's true, then good for him. But I feel like you learn the most about how to be a trial lawyer by into trial and getting your ass kicked. It's just sometimes you gotta hit the flames to turn into something special. Here's a question. How do you get access to depositions, and have Blake and Ryan been deposed by Freeman? I doubt it. What's up, Crow? I saw Crow. She was wanting to get on the show. I completely missed it. But she wanted to get into like the, what do you call it? We were having a political discussion. She wanted to jump in and chime in with stuff. I missed her comments because I was yelling at Brad the whole time. But I'm actually really interested in what Crow has to say or had to say. Maybe tomorrow when I readdress that issue. Pot Rock says Blake Lively photoshopped as the woman statue at the forefront of the Titanic, 2 miles underwater. Not sure what that means. So I guess, look, in short, there's all kinds of things that could happen as a result of that subpoena. I don't think that Friedman wants to necessarily settle the case, but if he could gut their lawsuit from the inside out and get them to change attorneys because they've been acting in bad faith, and that was like sanctions that they had to deal with, that's gonna suck for Lively. Because not only is she not getting out of this lawsuit, because if Friedman wants a trial, he's going to get one. But now they don't have any evidence to present their own side. So then it's like Friedman has really got nothing to lose. Whatever attorney is going to be coming in, like 5 months behind, and he's been on the case since August, so really 8 months behind. So there's some real danger right now with whatever is going to become of that subpoena. I'd imagine if Friedman's able to, he's going to file a motion regarding that subpoena if he suspects that it was born in bad faith, if only not to settle the case or not to dismiss the case, strictly for purposes of gutting the case on the Lively side. That's what I think is going to happen. So we'll see. ACAB True Crime says it's not about freedom or the money. It's about public image for Baldoni and co. They don't care about what the actual outcome of the case is, in my opinion. Yes, ma'am. And those are valid. I don't know if you're a ma'am. I called you a ma'am. Those are valid considerations. And that's usually the kind of cause that people with copious amounts of money to spend on litigation go for. Who was that lady? There was a lady that was involved in a skiing. I think it was Gwyneth Paltrow. She took had a 5-year lawsuit going on, goes all the way to trial and wins $1 because that's all she cared about was winning the trial. Sometimes it's like that. Yes, ma'am. April Love was $1. That trial was hilarious, by the way. Anyway, folks, that's all I got for you guys. Anita, do you have any closing remarks?
Oh no, it's all it's all good. I think I said everything I wanted to say.
Yes, ma'am. Yeah. Well, I guess we will see you tomorrow. Thank you for having
me.
Yeah, we'll see you tomorrow on Flab. We're going to start probably like at 4:30ish, my time.
Okay, sounds good.
Yeah, basically the same time as last time. And
sounds good.
We will see you then. For the rest of you folks, I love you all. Thank you so much for joining me late. And have a wonderful night. Have wonderful dreams. And we will see you all tomorrow. Bye-bye.